everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Jomol Joy with us. Her practice areas include cross-border mergers and acquisition, corporate financing, private equity transactions, securities and commercial litigation, dispute resolution, and more. Jomol's deals with experience cuts across sectors to include information technology, manufacturing, automotive, food and beverage, agriculture, and agri-tech and e-commerce. She regularly advises and counsels the senior management on corporate governance, policies, and strategy initiatives. As a commercial dispute lawyer, she has represented multinational corporations, educational trusts, societies, government, companies, and individuals across diverse forums, including the Supreme Court of India, High Courts of Delhi and Bangalore, National Company Law Tribunal, and Debt Recovery Tribunal 1 complex disputes. She pertaining to commercial contracts, shareholders agreements, company affairs, IPR, and more. She has also handled issues and investigations under the Foreign Corrupt Practices Act 1977, UK Bribery Act 2010, including comprehensive forensic investigations and review of work processes to advise clients on risk mitigation strategies. Safeguards under law and implementation of a comprehensive ethics framework. Her experience in criminal law practice involves handling defense and blue collar criminal matters, including sexual harassment and homicide. Without further ado, let's get to introduce Jamal herself. Hello, Jamal. Thank you so much for joining us today. And how is everything at your end?
Hi, Raima. Thank you so much for having me over. It's a pleasure for me. Well, everything's good. And how about you?
I am also doing amazing. Thank you so much for joining us today. And I'm so glad to know that everything at your end is good and you are doing amazing these days. So first of all, Jamal, to start the session with, I would first would like to know that in your professional career, you have transversed in different practice areas, including criminal and family litigation, corporate litigation, and then now general corporate and mergers and acquisitions and PEVC. So tell us about the experience and what has been your takeaway.
So, Raima, as I was telling you earlier before we started, that I have almost completed 8 years in the profession now. And in 8 years, I have pretty much traversed through different extremes of a spectrum, because I started off as a criminal litigating lawyer, where I used to handle rape matters, POXCO matters, murder cases. And this is when I actually started my career. And I started with the chambers of senior advocate, Mrs. Geeta Luthra. And she was very kind enough to give me these opportunities to take on matters, argue in court, right from the first day I had joined her, right? So while I was pretty happy doing that, I also had the chance to work on quite a bit of arbitration cases, because she used to be, she still is arbitrator on many state matters. And whenever I would assist her on those cases, I realized that probably my inclination as a lawyer lies more on this side. So that's how I moved on to Luthra and Luthra, because I knew the exposure in terms of corporate commercial litigation would be more. And from there, when I moved to AZB in Bangalore, again, I expanded my scope of practice. I was not just doing corporate litigation, but I also was doing general corporate matters. And there I got a taste or a flavor of transactions. So what I'm trying to say is that every step that I have taken so far in my career has been a very informed choice. It's not like I got bored of one place and then I moved to the other. That was never the case. And in terms of, takeaway, I would say that one thing that has been the underlying theme wherever I have worked is all these mentors have throughout taught me that my duty lies towards my client. When I'm representing my client, I should prepare, I should work in a manner that I'm fully 100% representing the client. If I have even the smallest of doubt that, whether I'm doing the right thing by representing the client, then I shouldn't, because then in that case, you're not in it completely. So even when you take on these rape matters, um, so another takeaway, as I was telling you earlier, is that, you know, um, you're making a bold decision to represent a rape accused, maybe sometimes in very sensitive matters where the public, the public opinion is against you. Sometimes you represent builders, and you know how these builder cases are. Like, you would have 400, 500 complainants. You go to the court, you receive death threats sometimes. Sometimes you'll meet people outside the court with a gun. Honestly, none of that ever bothered me. I still continued to represent as long as I thought I was right in doing what I was doing. And that, however, made me strong as a person, bold as a person. So it has helped me grow as an advocate also, because even on the corporate side, when my client sometimes feels um, dicey about certain things, I am there to support them and give them actual rationales as to why they should take a point of view. And that confidence actually comes from a lot of my experience in the past of me being either a criminal lawyer and facing really extreme situations. um, and I think um, the last takeaway was that it's never um, too late for you to make any choice at any given point. Age is not a factor. It can never be that you're too young or too old for something. So my husband is in Copenhagen, and he basically works with his other engineering colleagues there. And he tells me that most of his colleagues are not just engineers, but they also on the side do or take up a lot of other professional um, you know activities. So some of them are actually professional sportsmen, some of them are interior decorators, even managers, while they're also engineers. Whereas on the contrary, in India, that's not what we believe in. We believe that, okay, you have taken up something and now you have to run with it. That's a choice one person can make. The reason why I decided I wanted to be able to practice different practice areas is so that I am in a position to be a one-stop shop service for my client. So I can advise them basis, because sometimes my client, when the client comes to me, they would have queries not just relating to an IPR query, but they would also have queries relating to their ongoing corporate investigations, criminal investigations against their companies. So they feel confident coming to me because they know I have the experience to answer probably pretty much everything that they have to ask me. I'm not saying I know everything. I definitely don't. I'm barely 8 years into it. But at least there are a few practice areas that I can point my fingers at and say, hey, I have done this. I probably will be able to help you with it. So, and that's my aim as a lawyer also, to be able to represent my client in as many ways, in as many practice areas I can. Yeah.
Perfect, Jomo. Thank you so much for sharing your experience and answering that question so beautifully. And with that, I would like to move ahead with my second question of the session. So here, that the pandemic saw some courts begin moving more remote proceedings and availability. So, is this sustainable and a possible way to increase access to justice, in your opinion?
Um, so I think the way it is um, progressing today, or it's actually happening today, is more of a hybrid form. So, when the pandemic had just struck, and that time, too, of course, all the courts were closed, and then places started opening up gradually. Um, and then we saw that pretty much everything for a year and a half became e-court related because people were too scared to go to the courts. And in 2021, I was actually thinking about this. Then when I had joined this profession in 2014, uh, I would literally, I was, I was almost about to, write letters to the judiciary to uh, raise one issue before them, which was paperless courts. I was in deep shock as to the number of papers that we, end up, I won't call it a waste exactly, but then, you're making so many copies of one document. There is one court copy, there is one judge copy, there is one registry copy, and there is one senior advocate copy, there is your copy. And there are these big, big bundles. There are bags and bags of files going to the court. And you could not have possibly imagined uh, doing a matter if you're unwell. You are sitting at home, you can't go. Somebody has to take an adjournment, which means there's another date. And if there is a date, of course, there will be a delay. So when suddenly things switched to the E mode, I was in a way very happy because I realized that now at least people can think about it for future. I'm sure probably after, the pandemic sort of settles, I knew people will start going back to the courts and everything will become physical. That's what is happening today. But at the same time, people now know that it's not impossible entirely. Having said that, I think it's easier to implement, as, especially when it comes to our country in Supreme Court, High Court, etc., where the involvement of litigants, basically the people who are filing the cases through their lawyers, is less. In a trial court, you would require witnesses, and when you are taking witness statements, etc., you need your witness to be present in the court, because otherwise it so happens that the infrastructure when it comes to internet and other things is not so, it's not uniform across the country, right? So while a litigant who is sitting somewhere, in some remote part of the country may not have a good network, the court might have a good network, the court is still not able to hear you. So hence there are issues that, that one would face when it comes to witness statements and some of these proceedings which typically require your presence. I feel there are different, okay, there are cases, for example, when you're filing for an urgent relief in court, an interim relief, an interim order. Why not? Let it be an online proceeding, because at least, because the objective there is to get a quick remedy, right? And another advantage I have is I can engage a senior advocate from any part of the country. So I was recently speaking to one senior advocate in Delhi, and they told me that, they have been hopping rooms in their own office because they have different laptops set up in different rooms, and they have been taking these, so they've been attending these hearings, one for Karnataka, one for Delhi, one for some other place. So I was like, this is brilliant, which means you've been able to do many matters in one go. So I'm not talking about convenience of a senior advocate. What I'm trying to say is the accessibility to other lawyers from other states also increase. And if that's not more access to justice, what else is, right? So I think this is a very positive step. Having said that, um, I think that this has to be still hybrid. It cannot be a complete transition to e-court proceedings. Courts will have to now come up with rules as to what proceedings should be e-court, what proceedings should be, and those will have to be laid down and then brought into practice. It's going to take a couple of years for that, but I'm glad that at least it has started somewhere.
Absolutely, Jomol. Thank you so much for answering that question as well. Now, we would also like to understand that in the era of legal technology, what are the most commonly used tools for you?
So, Rama, when I was in a chamber as a litigating lawyer, my use of technology, to be very honest, it was there. There was a fair amount of usage in terms of your basic drafting tools, right? You'll probably rely on your standard MS Office and stuff like that. I also recall scenarios where I would be in the court, I would type out, so there would be these apps which would allow you to, basically you can download the MS Word in your phone. So it will allow you to sort of, type out your application sitting right there in the court. You will just email it to your clerk, he'll get it printed and bring it to you. I mean, there have been those days also. But then I feel that since the time I have moved to the corporate side, my reliance on technology has increased all the more. Now, actually, when this question came to me, I realized that, oh, actually, I've not given it a thought, but I have been actually using quite a bit of it. For example, for research, I no longer have to go to a library. I no longer have to look at these case records, which are physical. There is, there are these websites, there are these research platforms which are accessible, where you will find all your precedents in one place. I have closed so many big money transactions sitting on one side of the Zoom, and the buyer, let's say I'm the seller, the buyer on the other side. And we have closed transactions like this in 2020-21. So and I cannot imagine running my day without a calendar, a Google Calendar. So I think pretty much everything in the day, at least as a professional today, I am very much depending on technology. And I don't see anything wrong about it, because it's coming handy. It's not like an abuse of technology. It's actually one of those scenarios where your technology is coming handy and it's being used in the right way. So, yeah.
Thank you once again, Joel. Thank you for answering that question. So now, last but not the least, we would also like to know that time is money in any profession, and in legal, it's most of all. So how do you ensure to make the best of your time as a lawyer?
So, I have a bad reputation rather, of being a workaholic in my friend circle. I don't take it as a compliment at all. Um, but the fact is that if there's work, I would like to finish it at the earliest, so that the turnaround time when it comes to my client, it's as minimal as possible. I know, like, when you're thinking from a client's perspective, and I think it comes right from where I have started. When you are applying for a bail, time is sensitive, right? Because you're applying for an anticipatory bail, your client is right about to go to the jail, and it's really critical for you to get that bail for him to be out of it. So I think this whole concept of time being critical and sensitive when it comes to you as a lawyer has sort of settled into my life and my system since then. But it has just changed forms over a period of time. So now that in these couple of years, with the experience, whatever little experience I have, I've been able to sort of plan things better. So I would say my secret or my key to being able to, balance the time, or to ensure that things are done in a timely manner, is nothing but planning. But now I not just plan my professional life, but I also plan my uh, life in general. So right from, like, before I go off to sleep, I know that, okay, tomorrow morning, this is what is going to be, this is what the cook is going to make. If I have to take leave, say, sometime in March, I would have planned for it like today. I'm not going to wait until February, March. Things are planned, not because, okay, it's not about tickets getting expensive. It's about the fact that if I don't plan it now, I won't be able to plan my professional career, my career, I'm saying, sorry, calendar around it. So while work, so even there, I'm trying to see how things can be managed in a manner that the work doesn't have to suffer. So I think planning is the key, first of all, as far as I am concerned. And this is something my present partner, my boss, has taught me today, that plan ahead at least 15 days, at least 15 days. And I've taken it, like it's like the mantra for me now. And second, I feel that what helps me keep up with the time, um, especially when you don't have any, given the number of matters you have to juggle between, I would ensure that I'm taking breaks in between the work. so that the productivity is maintained. What happens is when you are, especially in a corporate setup, you're attending meetings, 6, 7 hours of negotiations back to back. Well, on those days, you can't help it, right? But then there are those days, so those will be, say, 10 out of 20 days in a month. You can't help it. But the remaining 20 days, you can plan your calendar around what you can do, right? So I try and ensure, even though those breaks might be just 10 minutes, 5 minutes, but I would take them. There's this notion of don't sleep while you are in office. Everyone, nobody, I'm sure. I don't know, Rama, about you. I mean, I have seen people around me, they're like, no, after lunch, I'm very sleepy, but I'm not going to take a nap because, oh my God, what will my HR, what will my boss say? I tell them, take a 10-minute nap on your desk. Take it, have a coffee, you'll feel very fresh. Then go for it. Then go for the work. Don't think what's the general notion. Of course, you're not setting up a precedent where people are just sleeping around in the office. That's not the objective. The objective here is how you can ensure you're making most of your time. So even if it comes to taking a nap, do it, which I do, by the way. Do it and then get back to your work with double force. So yeah, I think these small things in life, which you can manage as a person, is what helps me to manage time as a professional, I feel. Yeah.
Thank you so much, Jomo. Thank you for sharing such a great insight with us. The last question, personally, the last question is one of the favorites. Got to know how to manage time, how lawyers manage time in a very different way. Thank you so much once again. And we look forward to having a chat with you again in the future on some other trending topic in the international legal world. So for our viewers, if you like this chat with Jomol Joy, please like and share this video and also subscribe to ClickAway Creators YouTube channel to appreciate what we do. And we have more coming from the legal space for you all. This is Raima from LexTalk World signing off.